All right. Mr. Stern, whenever you're ready.
Okay, Your Honor, I'd like to reserve 5 minutes for rebuttal. Oh, I may finish way early than that. Your Honor, in a large part, this case is very simple. Due process required the clerk to do more than what he was statutorily required to do to notify my client of the tax deed sale on his property. The extra step the clerk took was to send notice by regular forwarded mail, which the
And didn't the clerk post it on the property as well?
Yes. It was posted. That's all wonderful, but that's not going to be enough. But the trial court said that mailing was sufficient simply because it was an extra step not required by the statute. Now, on the surface, that the court's ruling is supported by Jones versus Flowers. And Jones said, quote, "While due process does not require a property owner receive actual notice of a tax sale, the government's knowledge that notice pursuant to the normal procedure was ineffective triggered an obligation on the government's part to take additional steps to effect notice." Also, the Delta Property Management versus Profile Investment does say that one of those extra steps is notice by regular forwarded mail instead of just certified mail.
Can I ask you a question? I'm sitting here listening to that. Are you essentially arguing the statute is unconstitutional as applied to your client under the guise of the due
Yes,
process
that's the argument I've made.
Okay.
It's not unconstitutional as written, but as applied, yes.
Did you cite a case from the Second District of the Florida Supreme Court saying extra notice was required?
That actual notice was required?
Well, no, extra notice. You're saying they should have mailed it by regular mail, not just post on the property, not just follow the statute. Another step because your client didn't get notice.
Correct.
Okay, but where are the cases you're citing from?
Well, I'm citing primarily Jones versus Flowers, Facia versus Rosada, and Delta.
Are they federal cases?
Well,
The second DCA?
no, Delta is from Florida. Jones is the state Supreme, the U.S. Supreme Court.
US.
Yes, and Facia is Florida Supreme Court as well.
So we don't have anything from the second, but you've got two from the Florida Supreme Court.
Yes.
And I assume your opposing counsel will say they're not on point for some reason. So I'm going to see what they have to say.
Okay.
All right.
All right. So the letters were returned undeliverable and unforwardable. That's an exhibit attached to their motion for summary judgment. In this situation, Delta says the clerk's inaction after learning the notice was returned as undeliverable and not doing anything, that left the owner no better off than if the notice had never been sent.
Can you excuse me? It was the certified letter that was returned as undeliverable. Is that right?
In Delta? Or
no, in this case.
In this case, both letters were returned. And actually, they sent 4, 2 certified, 2 regular. All 4 were returned as undeliverable and unforwardable. And as I said, that's an exhibit to their motion for summary judgment. In Facia versus Rosado, the court said.
So the clerk is required to track down a taxpayer who failed to update his or her address?
Yes.
All right, I will talk to you.
Yes. That's what
If you don't leave me.
that's what Jones says. Now,
What
I
if
don't know.
this-
Well, pardon me. Tracking down may be the wrong phrase or wrong term, but when you're dealing with a sale, a forced sale, the court clerk or due process does require the court to do more than what the statute says.
What if, well, they did do more, didn't they?
They mailed the letter by regular mail and it was returned. They knew it was ineffective.
Right.
Which is that?
They posted it on the property, which I think the Supreme Court in Jones sort of singled that out as a really good way to get someone's attention at least.
Except it was either in that same case or another one where they said the notice could just as easily have been ripped down without
What about
anybody ever seeing.
but what about the forwardable mail? Like what remind me, I'm sure it's in your brief, but remind me what they were supposed to do besides forwardable mail that would have gone to a forwarding address if the taxpayer had bothered to forward the mail?
Very simple. We're dealing with a corporation, not an individual, which own the property.
Go on the Secretary of State's website.
Yep, absolutely. That was the
So-
one.
Go
Ma'am,
ahead,
that was the
go ahead and
one.
answer.
Okay, that is the one method that was certain.
Aren't corporations,
notice.
shouldn't corporations, if you want to incorporate in Florida, you should, I mean, you look at the law says this is all the clerk or the taxing authorities have to do is send it to your address on file. Does due process require something more?
Yes.
If
Well,
someone who decides to incorporate in Florida doesn't bother to find out what the law requires of them, which is to update their address?
The law does require you to update your address with Sunbiz, which is what they did.
Okay, Mr. Stern, so then I was gonna ask you, well, what if this was an individual? Then what does the clerk have to do?
Well, remember, the extra steps that have to be taken vary with the reasonableness and the particular circumstances.
So corporations are gonna get treated more favorably than an individual?
I don't know if
Because
it's favorable treatment as much as it is taking advantage of the resources that are out there. I mean,
Well,
why
what
is,
if they can Google an individual, and there are plenty of websites that will give you their address.
well, then perhaps maybe due process does require the court clerk to do that. Well, we're not dealing with that particular situation here, but remember, as I said, we're not talking about a situation of just collecting the taxes. We're talking about a situation of a taking of property. That does bring in due process concerns, and the Supreme Court has said it requires more than just what the statute requires. It's not comparing apples to, it's comparing apples to oranges.
Yeah.
Otherwise.
I mean, I understand your point that it seems like a simple thing to just go on Sunbiz and check it out.
An incredibly simple thing. Why wouldn't they do that? What did it cost them? No money and 30 seconds. They didn't do it because they didn't want to. Simple
Money,
as that.
it costs the taxpayers more money to send it to the address, to both addresses. Other taxpayers, not the taxpayer who didn't pay
I mean,
the
they went
taxes.
through a lot of effort to say that they just couldn't be bothered. Look at all the things they did do. I don't
Right.
think that's,
And if
a
they just-
fair statement. I mean, they jumped through a lot more hoops than just for
Right.
30 seconds, let me Google Sunbiz.
Sure they did, but if they went to Sunbiz first, they wouldn't have had to do anything else, would
No,
they?
no. Oh, wait. Let me ask you this. If they went to Sunbiz first, that goes to my point I just made. If they went to Sunbiz first, is you've moved. Your registered agent is over here now. I'm going to send it there instead of the address you have on file. And then what if they were actually at the address you had on file and they said, oh, no, we never pick up that mail. I think you might be wrong about that. And so my point is, there might be a cost to these agencies, to taxing authority. It has to send out 2 notices by your logic. So,
Well,
I'm
they
gonna
did
have-
that anyway. They did that anyway. They could have sent the 2 notices to the 2 different addresses, and it still wouldn't have been any further work for them or any cost for them.
So they caught the other taxpayers of Florida had to pay for an extra notice because they tried to track down the delinquent taxpayer. And what it's due process violation because they didn't do a third thing and pay for extra paper and postage to send it to a third option, which would be the putative address on the
Well-
Secretary of State site.
Your Honor, I think what you're arguing honestly is a de minimis burden on the court clerk. If they have the correct updated address from
How do they
Sunbiz,
know which one's correct if there's an address on file with the property appraiser and then there's on the tax collector and then
Because-
Sunbiz has a different address? How do they know which one's correct? Why don't they just go with the one the statute says?
and the statute would say it's the one with Sunbiz, because the statute requires Sunbiz, them to keep the corporation's address updated regularly with Sunbiz.
Boy, it
That-
seems
that's
like it
why
would have
it's
been
certain.
easy enough to update your address with everybody when you did that, or even put in a postal change of address notice so that your mail gets forwarded to your new address.
I understand all that, and I have not been arguing and I even said this in my briefs, that RISA didn't do a good job of maintaining its address. They probably should have. But my point is that the clerk is still burdened with due process requirements of seeing that that notice goes to that they use every reasonable method of giving notice. And I don't see how you get around not going to Sunbiz as being reasonable.
Is that the standard?
I think it should be the standard. I think this, if I was the governor, I'd say to the legislature, can you amend the statute to say that? But I'm not there. But the court of
I
clerk.
think they did, didn't they?
Excuse me? Well, they did amend the
did
statute
amend it.
recently, yes, but
Yeah.
that's not sufficient. And the statute says that the court clerk doesn't have to do this, this, or this, as well as has to do A, B, and C. But the U.S. Supreme Court has said, no, they still have to do those things that the statute says they don't have to. So it's unconstitutional as applied in this particular case. When you're dealing with a corporation, the simplest, easiest, and surest thing to do is to just check Sunbiz for their address. Off goes the letter, you're done. They didn't do that because they didn't want to. It's really that simple. And even in Jones, the court said this, that there's reason to believe the state will be more zealous in its efforts to collect taxes than it will be in its efforts to give notice of taking a property. That's exactly what's happened here. Exactly what's happened here. It's therefore, quote, it is not too much to insist that the state do a bit more to attempt to let the property owner know about it when the notice letter addressed to him is returned unclaimed. And it
But
says
did that say it had to do, what it had to do more? What about the affordable mail? Is that more?
yes, because the statement I just read to you says when the notice letter doesn't say by certified mail or regular mail, it says letter.
Okay.
All right, and earlier in the case, they do use the term mailed by itself.
Yeah.
So
Okay.
my point to you is all you have to do is ding, ding, ding. There's its address. Okay, off goes the letter. And they're saying we didn't have to do that. We did these dozen other things and we still didn't notify the property owner. And that complies with due process? I don't understand that one. In any case, there's my argument. I just say that the trial court's order should be reversed. The sale should be voided and new sales should be held. Thank you.
Thank you. Ms. Donald?
Yes, may it please the court. My name is Ashley Donnell. I have the privilege today of representing Ken Burke, Clerk of the Circuit Court and Comptroller for Pinellas County, Florida. I will be doing the majority of arguing. However, I will yield 2 minutes as agreed with Mr. Cheatham, who represents Applee Colin KG. Your
Okay.
Honors, thank you. Your Honors, in this case, the noticing efforts that the clerk undertook were reasonably calculated to apprise the appellant of the pending tax deed sale. The requirements for notice under Florida Statute 197.522 are constitutionally sufficient for due process, and the clerk undertook those efforts. The clerk did at the onset additionally send notice by regular forwardable mail in an effort to additionally notice the appellant. I would note that the appellant had 2 different addresses. There was the parcel in Pinellas County, which was a gas station. It was a commercial property, as well as their mailing address, which was in Palm Beach County. Under the statute, the clerk posted notice at both addresses, as well as sending certified mail of the pending tax deed sale and regular mail, also advertising in the newspaper 4 times, the Business Observer, and recording the notice of the tax deed application. That is all required by law, and that is what the clerk did. So the reason that Mr. Stern brings up concerns about why didn't the clerk just go on Sunbiz? I mean, that's sort of the question here. And it is not that the effort in itself of going onto Sunbiz would be so unduly burdensome. It is more the burden of asking the clerk to deviate from his ministerial function and instead look at these cases on a case-by-case basis and have to make determinations about what other government records maybe that should be researched. Case law
Just tell us
says,
why Jones doesn't apply here. What's the distinguishing feature between this case and his argument that Jones requires more than a ministerial?
yes, Your Honor.
compliance?
Your question is to make a distinction between Jones v. Flowers and our circumstances, correct? So in the Jones v. Flowers case, notice was only sent by certified mail. This was in Arkansas, and the noticing requirements in Arkansas at the time didn't have the lengthy requirements that Florida has under Chapter 197 in our statutory scheme for noticing for tax deed sales. So in the Jones case, a letter was sent by certified mail to the owner 2 years prior saying, if you don't pay your taxes in the next 2 years, your property is going to be sold. 2 years later, another letter said the sale is pending, and all of those were returned unclaimed. But that is the only effort that was taken in that case. So the Jones v. Flowers case goes on to suggest many other reasonable efforts that could be taken to be calculated to apprise the title holder of the pending action, such as posting, such as regular forwardable mail. And those are all efforts that Florida already has codified under Chapter 197. So if you're looking at the Jones case through the appellant's eyes, you say, hey, returned mail means tax deed invalid. But if you do a further inquiry into the case is actually saying that there have to be other efforts made. In this
What about
case,
Vozia versus Rosado? The argument was made there that, hey, you should have kept your address up to date, but the argument was rejected by the Supreme Court.
in the Vocilla v. Rosado case, the specific distinction between our facts and the Vocilla v. Rosado is that the Florida Supreme Court goes into great detail about distinguishing title holders who took some action, or there was some unique information received by the government entity, the taxing authority, and those who did not. So in the Vocilla case, the title holders had actually attempted to change their address with the taxing authority. Whereas here, Resa Petroleum, the appellant, did not take any of those efforts. And specifically when
It's almost like in Vocilla, it was negligent. In other words, it was unreasonable because it was like, hey, you should have checked for a change of address. It's right there. As opposed to, go ahead.
Yes, Your Honor, because there had been some indication that the taxing entity would have been on notice, it was the taxing entity's mistake that there had been a change of address submitted. There had been no action taken within the taxing authority's office, so the address was not updated. And because of that, the title holders were entitled to have the tax deed sale invalidated because they had done their due diligence and they had kept up to their accountability as a taxpayer who should know that taxes are due under Chapter 197. There is some onus placed on the title holder. And so that's the big distinction between our facts and the Vocilla case. And I would note that in this case, we have a title holder who's not paid taxes for a number of years, contrary to the law. Why would the clerk then assume that the title holder is going to follow the law and change their address with Sunbiz? I mean, that again is a discretionary determination that is an undue burden on the clerk, who in his ministerial function is charged with following the law as written. And in this case, which he did do, there's no dispute that the clerk in this case followed the noticing requirements of Chapter 197 to the letter of the law and did one additional reasonable step for notice by sending that same notice by regular forwardable mail. But when Mr. Stern for the appellant argues that the clerk should have done some type of a search, I mean, there's case law cited in the Vocilla v. Rosado case, and specifically Kidder v. Cirelli, which is at page 295 of the Vocilla opinion, where that court held that the clerk has no responsibility to search for the proper address for a title holder. Because again, under Chapter 197, title holders are charged with knowing that taxes are due and payable annually, and they have to avail themselves to receive information about their taxes. There's no specific authority that says, as a title holder, you must absolutely update your address the day you change your address with the taxing entity, but you're responsible for paying your taxes and availing yourself of receiving that information. So in this case, I would argue this is not an as applied constitutional challenge, but in fact, it really is a facial constitutional challenge, because the case law all supports that just the virtue of returned mail does not invalidate a tax deed sale, especially when you look at the totality of the circumstances of the noticing efforts undertaken by the clerk. The clerk was charged and performed his ministerial duty. And while the legislature does not determine due process, I would argue that there is the language of the statute changed in 2018 to specifically say the clerk has no additional duty to ascertain information and can rely upon the tax roll for the tax roll for that taxing year. And in fact, that is again what happened here. So I would argue that the clerk absolutely prevails in this case, because while the clerk met his ministerial obligations and took an additional reasonable step, the appellant did not avail themselves to be receptive to information about taxes, which they are charged with knowing are due and payable. And the notion that the clerk should do an open-ended search, which is discouraged and held as not valid in the Jones v. Flowers case, as an open-ended search, is contrary to the law. It's not open-ended in the fact that if you go on Sunbiz and type in the name, you're not going to receive information. The open-endedness is the vast other types of resources you could go to research about a particular title holder, and the fact that the clerk then has to deviate, make discretionary decisions, determine whether or not that information is valid, determine whether or not the clerk needs to then send additional notice, additional postings, which of course does incur more costs. All of those additional burdens are not contemplated by the law. The Florida Supreme Court has held in an opinion that the noticing requirements as written in 197-522 are sufficient for procedural due process. So in this case, the clerk would argue that RESA was in fact afforded due process, and the fact that they didn't receive actual notice does not invalidate the tax deed sale, because the United States Supreme Court has held actual notice is not the litmus test for due process. It's whether the efforts were reasonably calculated to apprise the interested party of the pendency of the action and give them an opportunity to be heard. So if there are no other questions, I will yield my time to Mr. Cheatham.
Hey,
Okay.
thank you.
You're on mute, Mr. Hughes.
Mr. Cheatham, yes, you're on mute.
I'm sorry. You'd figure I
No
would learn
problem.
not to unmute myself by now.
We should-
I represent Colin KG, the purchaser at the tax deed sale. I have to just mirror everything Ms. Donnell has said. The open-ended search, or the need to, where do you stop? And as one of the justices said, I don't remember which one at the beginning of the appellant's argument, what if the address on Sunbiz was wrong? Where do you stop? The legislature codified the due process requirements in Chapter 197 or Section 197.522. It's meant to give the clerk concrete directive as what they are required to do.
Well, let me ask you a question, because you're mentioning your argument after the fact that the statute is modified, say that's enough. Why did they do that? If it was enough when they did it, did they make that change in the statute because it wasn't enough when they did it? And what's the purpose of that argument?
Honestly, Judge, I don't know the answer to that question. The purpose of the argument is they've done everything the law says they have to do, plus they did more. And the Jones, Supreme Court Jones case certainly says you have to do more than just a simple letter. In this case, the notice was posted on 2 different properties. 4 letters were written. It was published.
Let me
They
can I
did.
follow up on Judge Valente's question and say, what under the version of the statute in effect at the time that notice was attempted or accomplished effectively, constructively, what at the time was sufficient? In other words, I believe, I don't want to put words in Judge Valente's mouth, but in other words, now it's statutorily definitive that that's sufficient. Before, what made it definitive under 197.522 before it was amended in 2018?
Yours up.
I think you're maybe, hello?
Trying to read the caption, and then the caption went away to look up your question.
I'm having trouble
And my screen is
understanding Mr. Cheatham.
We did not hear your answer.
Mr. Cheatham? I think your connection is having difficulty.
Jackson, I couldn't question. My screen is frozen with you.
Oh. Okay.
Oh, go ahead. Don't worry about it. Hello? Can anyone hear me?
I hear you,
Hear you
Mr.
fine.
Cheatham.
I can hear him.
If I don't think Mr. Cheatham can hear me, so that's okay. Just move. Should someone else ask a question, or Mr. Cheatham go ahead? Or someone can tell Mr. Cheatham to go ahead because he can't hear me.
Mr. Cheatham, please go ahead and
Yes,
see if you can answer the question.
I was happy.
He couldn't hear my question, but I'll withdraw the question.
Well, just ask me if you have anything else you want to add. I mean, we can pause the ceremony here, so to speak, or you can just give us the high sign. We'll move on to your opponent. Okay.
Okay, you can, well, why don't you try turning off your camera, Mr. Cheatham, and just talking to us, see if that works.
Okay, my video is off.
All right.
Okay,
Now
we can
have
hear
one-
you. Judge Atkinson, you want to ask your question again? Do you remember it by any chance?
Oh, sure. I can't remember Judge Valente's question, so I was going to try to piggyback off of, but I'll ask my question, which may or may not answer Judge Valente's. What you were talking about, I mean, under the current statutory regime, the current statute codified that notice to a certain address is, definitive. And I think Judge Valente was just raising the possibility that casts doubt on whether under the previous version, notice to a specific address was definitive. And I was asking you, under the version of the statute in effect at the time of the notice was sent, why was it definitive? This positive.
Because the statute codified the due process requirements within the terms of what the tax collector or the clerk had to do. So,
but nonetheless, Bozia v. Rosado said just compliance with the statute may not be enough.
but in this case, we know the clerk did more than what the statute required.
I'm assuming your position would be that the clerk didn't have to, because what your co-counsel, or not co-counsel, but counsel for the other appellee, said that you only have to do so under Bozia v. Rosado in the event that there's some indicator or some indication from the taxpayer that there's been a change of address.
Well, as my co-defendant counsel pointed out, in the Bozia case, there was an attempt by the taxpayer to correct the address, and the clerk did not pick up the change of address. So that was, as it was pointed out earlier, that was almost like a negligent situation where the clerk had not properly recorded the correct
Is
address.
returned mail you know, effectively the equivalent of being on notice, the address has changed?
Well, if the taxpayer attempted to change the address, the returned mail may or may not have been. I don't know. I wasn't obviously not involved in that case. And as the purchaser at the tax deed sale, Mr. KG has to rely on the clerk doing what the law says they have to do.
Mr. Cheatham, are you
I'm-
still there?
Yeah, I'm still here, Your Honor. I have no idea what's going on with,
Okay, well,
with-
It's your argument. It's still your argument.
well, you have
Until Judge
about
says
2
no.
minutes left if you want to wrap up your argument.
I don't have any other argument, Your Honor.
Okay, all right, thank you, thank you. All right, Mr. Stern, you can unmute and have your rebuttal time.
Okay. I'll deal with two issues. First, the search being open-ended. It's simply not. Even in the context in which opposing counsel meant it, that you could search several other sites and get different addresses. There's one official site for the Secretary of State which maintains corporate records. That's Sunbiz, period. The law requires the corporation, every corporation, to keep its address updated, and it's posted there, period. You
So now
start.
let me ask you this. Okay, so for the Rosado case, there was some indicia that there was an address change. In other words, there was some, not just indicia of address change, but an effort on the part of the taxpayer to
Right.
make that known, which I believe one way to read that case is that reasonable is in the context of, in that context. In other words, it was negligence on the part of the governing authority not to communicate with each other or just find out whether
Yeah,
a
look
change
at
of
it,
address.
look at its own records.
All right, your question raises the point I was going to get to, and I want to read you 3 quotes from Jones versus Flowers, and
Okay.
that'll conclude everything. Just give me 1 minute and I'll be done, because I tend to read pretty
You
quickly.
got 3, but.
Actually, by my count, I've got 5, but that's all right. It's quote, knowledge that notice was ineffective was one of the practicalities and peculiarities of the case taken into account. None of the commissioner's additional contentions that notice was sent to an address that Jones provided and had a legal obligation to keep updated, that a property owner who fails to receive a property tax bill and pay taxes is on inquiry notice that his property is subject to governmental taking, and that Jones was obliged to ensure that those in whose hands he left his property would alert him if it was in jeopardy, relieves the state of its constitutional obligation to provide adequate notice. Because additional reasonable steps were available to the state, given the circumstances here, the commissioner's effort to provide notice to Jones was insufficient to satisfy due process. I think that ends the argument, Your Honors.
Far
They
be
have
it from
to
us
do
to second
something
guess
more.
the United States Supreme Court. Far be it from me to second guess the United States Supreme Court, but that does sound open-ended. If additional steps are available,
Mhm.
so you
Right.
just have to keep looking everywhere. That's where you're construing that until
I'm
you find them.
I'm
The clerk has to
construing
keep
it.
looking until they find them.
No, because that says that would be an argument for actual notice. And the case is somewhere in there, they do say that's not a requirement. But but when you know, I think this may be the dividing line. When you know definitively that your notice was unsuccessful, then you've got an obligation to go forward if it's reasonable to do so.
So in other words, the distinction in Rosado is not just that the governing authority was on notice that that may not be the correct address anymore. Or you're saying that was the distinction, as opposed to another thing you can infer, which is that there must be some effort that is to convey that to the government by the taxpayer. And if it was conveyed to the government, then the government's got to,
Well,
keep its head screwed on straight and say, hey, they told you they moved.
well, exactly. I mean, what they're doing essentially what opposing counsel has said they should do is they're giving you the notice. Maybe it got lost in the clerk's office somewhere. what did happen in one of those cases. But the taxpayer did what, they did comply in that case. I'm saying,
How did this taxpayer comply?
oh, in that
Anything.
regard, no. And I even said to you in my opening argument that you can definitely accuse my client of not doing a good enough job, or not doing a very good job to keep the state updated with its address, or at least in the property taxes. But the corporation still kept the state notified of its address through Sunbiz. And the clerks know that. They know what Sunbiz is. They know where the records are. They know that they're required to be there. So what's the problem? I don't understand how they can seriously argue, we didn't have to check that. We sent them a letter. It got returned. We knew that. So what? We're done. We've complied with our duties. Let's move on. Your property is lost.
And
I cannot
speaking-
believe the US Supreme Court would say, that's all right.
Mr. Stern, and speaking of moving on, you are at the end of your time. So
Thank
we
you.
are going to move on. Thank you both. Thank all three of you actually for your arguments today. And
Thank you.
we're going to proceed